Information all people and public officials should be taught or reminded. Fundamental laws and constitutional concepts essential to our freedoms. Something to learn. It doesn't matter if you are a mom, dad, teacher, business professional, politician, law enforcement, or what you do for a living. This overview will be beneficial for all to know. We the people have discovered that what was taught or implied regarding our government is not necessarily true. If you want to learn things that have been hidden from you, especially if you are involved with politics, on a school board or associated with county, city, or state government, a county precinct chair, or affiliated with a political party organization or clubs, or law enforcement, there will be something surprising to learn in this video. Let's first go over fundamental principles and maxims of law, and this is taken from Charles Wiseman Maxims of Law. In law, as with any science, there exist certain fundamental principles which form its basis and to which reference must be frequently made in its application. These fundamental principles in law are referred to as maxims of law. These maxims of law are so manifestly founded on reason, necessity, and divine precepts that they have been universally accepted as being true rules and principles of law. A maxim is so called because its dignity is chiefest and its authority the most certain, and because it is universally approved by all. And that was a quote by Sir Edwin Coke. He was a primary resource used by the Founding Fathers in the application of our constitutional laws. Fundamental principles referenced in law. I started with fundamental principles because that concept is referenced in some of our state constitutions. Here are two examples. Arizona Constitution, Article 2, Section 1, Fundamental Principles, Recurrence 2. A frequent recurrence to fundamental principles is essential to the security of individual rights and the perpetuity of free government. Vermont Constitution, Chapter 1, Article 18, regard to fundamental principles and virtues necessary to preserve liberty. That frequent recurrence to fundamental principles and a firm adherence to justice, moderation, temperance, industry, and frugality are absolutely necessary to preserve the blessings of liberty and keep government free. The people ought, therefore, to pay particular attention to these points in the choice of officers and representatives, and have a right in a legal way to exact a due and constant regard to them from their legislators and magistrates in making and executing such laws as are necessary for the good government of the state. And magistrates means public officials. Government answers to the people. Who elected public officers to their positions? The people. All government originates with the people. The people elected public officials and provided funds for government operations. All political power and authority belong to the people. Alaska Constitution, Article 1, Section 2, Source of Government. All political power is inherent in the people. All government originates with the people, is founded upon their will only, and is instituted solely for the good of the people as a whole. In the Alabama Constitution, Article 1, Section 2, People's Source of Power. That all political power is inherent in the people, and all free governments are founded on their authority and instituted for their benefit, and that, therefore, they have at all times an inalienable and indefeasible right to change their form of government in such manner as they may deem expedient. And inalienable means it cannot be separated from them or transferred from them, and indefeasible means it cannot be made void. Maxim 51.0. All political power is inherent in the people by decree of God. Thus, none can exist except it be derived from them. Public servants, not leaders. Public officials are not leaders. They are public servants to the people, also referred to as magistrates or agents of the people. All public officials are always accountable directly to the people. And here are two different state examples showing this. Vermont Constitution, Chapter 1, Article 6, that all power being originally inherent in and consequently derived from the people, therefore all officers of government, whether legislative or executive, are their trustees and servants, and at all times in a legal way accountable to them. The Virginia Constitution, Article 1, Section 2, People the Source of Power. that all power is vested in and consequently derived from the people, that magistrates are their trustees and servants, and at all times amenable to them, and amenable means accountable to. Maxim 11b. The derivative power cannot be greater than the original from which it is derived. Public servants are to enact the people's will. Public officials are agents of the people elected into a position to fulfill the people's will, not their own will. Here's an example shown in the Georgia Constitution, Article 1, Section 2, Paragraph 1. All government of right originates with the people, is founded upon their will only, and is instituted solely for the good of the whole. Public officers are the trustees and servants of the people and are at all times amenable to them. Here's a maxim, 4d. An agent is a person authorized by another to act on his account and under his control. A public official's role is to represent the people that elected them. A representative is one who acts and does according to the will of the ones that elected them. The role as a substitute. Elected public officials become the people's substitutes and agents to carry out the people's instructions. Here's an example from the Massachusetts Constitution, Part the First, Article 5. All power residing originally in the people and being derived from them, the several magistrates and officers of government vested with authority, whether legislative, executive, or judicial, are their substitutes and agents and are at all times accountable to them. And here's a maxim, 4f. Faith must be observed. An agent must not violate the confidence reposed in him. Substitute agent analogies. If you are a substitute teacher, the teacher provides lesson plans for you to carry out in their absence. The substitute is there to carry out the teacher's plans, not implement their own lesson plans. If you work as a representative agent for a corporation, when you show up to a client's office on behalf of that corporation, you are there to do the will of your employer, not your will. Public officials work for the people and are their substitutes and agents with an obligation to carry out the will of the people. Government should be open and responsive. Government officials are always directly accountable to the people. Therefore, the people have every right to access governmental records, being the ones that instituted government. Government officials work for the people. Similarly, representatives working for a corporation are required to turn in reports and records to their employer. Here is the law shown in one of our state constitutions, New Hampshire Constitution, Part the First, Article 8, Accountability of Magistrates and Officers, Public's Right to Know. All power residing originally in and being derived from the people. All the magistrates and officers of government are their substitutes and agents, and at all times accountable to them. Government, therefore, should be open, accessible, accountable, and responsive. To that end, the public's right of access to governmental proceedings and records shall not be unreasonably restricted. Government should be lawful and accountable. This is from the New Hampshire Constitution, Part the First, Article 8, continued. The public also has a right to an orderly, lawful, and accountable government. Therefore, any individual taxpayer eligible to vote in the state shall have standing to petition the Superior Court to declare whether the state or political subdivision in which the taxpayer resides has spent or has approved spending public funds in violation of a law, ordinance, or constitutional provision. In such a case, the taxpayer shall not have to demonstrate that his or her personal rights were impaired or prejudiced beyond his or her status as a taxpayer. However, this right shall not apply when the challenged governmental action is the subject of a judicial or administrative decision from which there is a right of appeal by statute or otherwise by the parties to that proceeding. The people's right to access public records. This is a law, and here is an example in one of the state constitutions, Florida Constitution, Article 1, Section 24, Access to Public Records and Meetings. A. Every person has the right to inspect or copy any public record made or received in connection with the official business of any public body, officer, or employee of the state, or persons acting on their behalf, except with respect to records exempted pursuant to this section or specifically made confidential by this Constitution. This section specifically includes the legislative, executive, and judicial branches of government and each agency or department created thereunder, counties, municipalities, and districts, and each constitutional officer, board, and commission or entity created pursuant to law or this Constitution. Public officials denying the people access to public records is maladministration, a breach of their trust agreement, and a crime. The people's right to instruct their public officials. The people have the guaranteed right to instruct their representatives. It is their duty to instruct and direct the public servants regarding the people's will. And here is one example where this is shown as law in the main Constitution, Article 1, Section 15, right of petition. The people have a right at all times in an orderly and peaceable manner to assemble, to consult upon the common good, to give instructions to their representatives, and to request of either department of the government by petition or remonstrance redress of their wrongs and grievances. Government's duty to provide remedies. Government exists to provide a remedy for oppression, injury, or any wrongs done to the people known as the redress of grievances. Congressional sessions are not to provide programs that enlarge or enrich government or corporations, but to provide remedies for the people. The people have the right to approach government officials to protest against any policy or conduct of the government or government officials. And here is one example that's stated in the law. This is from Maine State Constitution, Article 1, Section 15. The people have a right at all times in an orderly and peaceable manner to assemble to consult upon the common good, to give instructions to their representatives, and to request of either department of the government by petition or remonstrance redress of their wrongs and grievances. And here is a maxim 94H. It is just that every person is entitled to a certain remedy in the laws for all injuries or wrongs which he may receive in his person, property, or character. And remonstrance is just a formal protest against a government policy or against a government official. The people's protection, security, and benefit. The purpose of the government and all of its agents and agencies is to provide protection, security, and benefit for the people. And here's one example of where this is shown in law. This is from the North Dakota Constitution, Article 1, Section 2. All political power is inherent in the people. Government is instituted for the protection, security, and benefit of the people, and they have a right to alter or reform the same whenever the public good may require. Maxim 51P. The main object of government is the protection and preservation of personal rights, private property, and public liberties, and upholding the law of God. Public officials are to ensure the protection, security, and benefit of the American people, not to benefit special interest groups, corporations, lobbyists, political parties, other countries, or to enlarge or enrich the government. It is all about the American people. Regulating government. The people created the government. Therefore, they have the right and responsibility to regulate that government. Consequently, government should be open, accessible, and responsive to the people. Here's an example of the law in Georgia Constitution, Article 1, Section 2, Paragraph 2, Object of Government. The people of the state have the inherent right of regulating their internal government. Government is instituted for the protection, security, and benefit of the people, and at all times they have the right to alter or reform the same whenever the public good may require it. Bound by oath of office. All public officials are required by each state constitution and the federal constitution to take an oath of office, which must be signed and notarized before beginning their terms. These oaths are not required from the American people, only government officials. Why? Because the American people are not governed by the constitutions. Only government officials are governed and bound by the constitutions. The constitutions are written as instructions specifically to government workers. Public officials must agree to the terms of the constitutions before they enter into office. The people are free and independent of the constitutions. People are free and independent from government. So here is a diagram for you. So we the people existed first and wrote down our rights called the Bill of Rights, and some states call them Declaration of Rights. And the people are the ones that established government. We, the people, created constitutions which states what limited authority government has to operate on our behalf. Elected officials are required to take an oath of office, which binds them to uphold our rights and the constitutions. The purpose of government is to secure the rights of the people and to protect and benefit the people. And here is an example from one of the state constitutions of where it states in law that the people are free and independent. California Constitution, Article 1, Section 1. All people are by nature free and independent and have inalienable rights. Among these are enjoying and defending life and liberty, acquiring, possessing, and protecting property, and pursuing and obtaining safety, happiness, and privacy. Public officers are trustees. Public officers are referred to as trustees in some of the state constitutions because the constitutions are express trust agreements. The constitutions govern the actions of the trustee, therefore they are also trust indentures. When the officials take the oath of office, they enter into this agreement and become a trustee. Here's an example where this is stated in law from the Georgia Constitution, Article 1, Section 2, Paragraph 1, Origin and Foundation of Government. All government of right originates with the people, is founded upon their will only, and is instituted solely for the good of the whole. Public officers are the trustees and servants of the people and are at all times amenable to them. And the Federalist Paper No. 46, written by James Madison in 1788, also mentions this. The federal and state governments are in fact but different agents and trustees of the people, constituted with different powers and designed for different purposes. Administration. The trustee's purpose is to administer the terms of the trust agreement for the benefit of the people. Therefore, the constitutions state that government is instituted for the benefit of the people. The people are the beneficiaries of the trust agreement. Government exists to administer the laws on behalf of the people. The people have all political power, thereby making the people the trust protectors as well. Breach of trust. A person elected into office becomes a trustee bound by a trust indenture for their particular state and the United States. This position comes with legal duties and responsibilities that by law must be followed. When a trustee fails to follow the trust agreements as written, they commit maladministration and violate their trust agreement, which is a breach of trust. A public official commits a breach of trust when any act done by a trustee is contrary to the terms of his trust or in excess of his authority and to the detriment of the trust. The wrongful omission by a trustee of any act required of him by the terms of the trust. The wrongful misappropriation by a trustee of any fund or property which had been lawfully committed to him in a fiduciary character. Every violation by a trustee of a duty which equity lays upon him, whether willful and fraudulent, or done through negligence, or arising through mere oversight and forgetfulness, is a breach of trust. And these definitions come from Black's Law, 4th edition. Maladministration. Government means the administration of public affairs according to established constitution, laws, and usages. That's from Noah Webster's 1828 dictionary. Public officials are managers of the people's public affairs. Officials are responsible for administrating public affairs for the people according to law. Maladministration is bad management of public affairs. It is defective conduct in administration or the performance of official duties prescribed by law. And that definition was from Noah Webster's 1828 dictionary. Consequences for public officials. When laws are not followed by public officials, it is maladministration, a crime, and a breach of trust. When an act violates a law or against any rule of a duty plainly implied in those laws, it is a crime. A crime may consist of omission or neglect. That's by Noah Webster's dictionary. Consequences for a breach of trust may include fines, removal from a trustee position, and jail time. The duty of the community. So not only do public officials have duties and responsibilities, but we, the people in the community, have a duty as well. Let's see what the law states about our duty. Virginia Constitution, Article 1, Section 3. that government is or ought to be instituted for the common benefit, protection, and security of the people, nation, or community. Of all the various modes and forms of government, that is best which is capable of producing the greatest degree of happiness and safety, and is most effectually secured against the danger of maladministration. And whenever any government shall be found inadequate or contrary to these purposes, a majority of the community hath an indubitable, which means it cannot be questioned; inalienable means it cannot be transferred; and indefeasible, which means it cannot be made void, right to reform, alter, or abolish it in such manner as shall be judged most conducive to the public will, that is, prosperity and happiness. So it is the people in the community that has the responsibility to reform, alter, or abolish it as needed. Neglecting or restricting the people. When the people come to give their remonstrance and grievances to legislatures, city councils, county commissioners, or school board members, they are doing their duty to instruct the public official as their servant. The public official must listen and bring remedies to the people according to constitutional law. When people are not allowed to speak and are restricted in speech, the public official is violating the rights and duties of the individual, which is maladministration and a breach of their trust indenture. The authority to write laws. Who wrote the state charters and the state constitutions? It was the inhabitants, people of that area, who wrote the laws called the constitutions. The people granted authority only to the legislative branch to write and enact bylaws to fulfill the requirements laid out in the various constitutions. In the United States Constitution, Article 1, Section 1, it states, "All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives." And legislative means making or giving laws pertaining to the function of lawmaking or to the process of enactment of laws. And that's from Black's Law, 5th edition. Attorneys and lawyers are officers of the court and are under the judicial branch of government. It violates the separation of powers outlined in the Constitution to create a legislative council consisting of attorneys and lawyers to assist legislators in writing laws. No constitutional authority was granted for these councils. Here's an example from one of our state constitutions regarding the separations of powers. Texas Constitution, Article 2, Section 1. The powers of the government of the state of Texas shall be divided into 3 distinct departments, each of which shall be confided to a separate body of magistrates, to wit, those which are legislative to one, those which are executive to another, and those which are judicial to another. And no person or collection of persons, being of one of these departments, shall exercise any power properly attached to either of the others, except in the instances herein expressly permitted. The American Bar Association for Attorneys and Lawyers was formed in 1878. The U.S. Constitution was written in 1787. Bar Association members were not given authority from the people to write laws. Federalist Paper No. 51. The Federalist Papers were written to support and educate the public on a U.S. federal constitution. And this is taken from number 51, the structure of the government must furnish the proper checks and balances between the different departments. It was written in 1788. The author was either Alexander Hamilton or James Madison. Starts out, to what expedient, then, shall we finally resort for maintaining in practice the necessary partition of power among the several departments as laid down in the Constitution? And then another excerpt says, in order to lay a due foundation for that separate and distinct exercise of the different powers of government, which to a certain extent is admitted on all hands to be essential to the preservation of liberty, it is evident that each department should have a will of its own, and consequently should be so constituted that the members of each should have as little agency as possible in the appointment of the members of the others. In another excerpt, it says, it is equally evident that the members of each department should be as little dependent as possible on those of the others for the emoluments annexed to their offices. But the great security against a gradual concentration of the several powers in the same department consists in giving to those who administer each department the necessary constitutional means and personal motives to resist encroachments of the others. And finally, it says, a dependence on the people is no doubt the primary control on the government. Corporations. Each of the states and the United States are corporations by design. The statutes created by the legislatures are corporate bylaws that govern the internal operations of government. The law requires trustees to follow directives such as election laws, rules, and government codes on their business practices for the benefit and protection of the people. Rules for the government. Legislators were granted authority from the people to write rules for government to implement the laws of the constitutions. In the United States Constitution, under Article 1, Section 8 is where the powers of the Congress is listed, and under Clause number 14, it says to make rules for the government and regulation of the land and naval forces. It doesn't say rules for the people, it says rules for the government. Bylaws. The setup and establishment of the government are outlined in the constitutions. They are written to government employees, not to people in the private. It is a document that restricts government workers, not the people in general. The constitutions are bylaws for government workers. Bylaws are regulations, ordinances, rules, or laws adopted by an association or corporation or the like for its government. In other words, its internal direction. Statutes, rules for government. Constitutions state that which are authorized and permitted for public officials. Officials were permitted to write rules for government to handle the administration of public affairs, not over the private lives of the people to interfere with the people's rights and liberties. Statute means a permanent rule established by an organization, corporation, etc., to govern its internal affairs. In a case called Miranda versus Arizona, from the year 1966, it stated, where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Security of the people's rights. Legislators, whether state or federal, cannot write bylaws, statutes, that go against the rights, freedoms, or liberties of the people. To do so is maladministration, a breach of their trust agreement, and a crime. Bylaws must be in pursuance to the constitutions, and pursuance means agreeable with the Constitution. And here are two of our state constitutions that emphasize this. Texas Constitution, Article 1, Section 29. To guard against transgressions of the high powers herein delegated, we declare that everything in this Bill of Rights is accepted out of the general powers of government, and shall forever remain inviolate, and all laws contrary thereto, or to the following provisions, shall be void. Kentucky Constitution, Bill of Rights, Section 2. Absolute and arbitrary power over the lives, liberty, and property of free men exists nowhere in a republic, not even in the largest majority. Expulsion. The people, who have all political power, granted authority to Congress to punish its members for disorderly behavior and to expel a member. Here's an example in the United States Constitution, Article 1, Section 5, Clause number 2. Each House may determine the rules of its proceedings, punish its members for disorderly behavior, and, with the concurrence of 2/3, expel a member. The authority and power to expel a member originated with the people. Power can only be delegated if it is possessed by the original. If Congress can expel a member, the people can expel a member of Congress as well. Here's a maxim, 11F. Power can never be delegated which the authority said to delegate never possessed itself. Maxim 11J. One has authority when he has a legal or rightful power to act. Alter, reform, or abolish. The people, having all authority, can alter, reform, or change the government lawfully when deeming it necessary. Here is just one example from many of the main Constitution, Article 1, Section 2. All power is inherent in the people. All free governments are founded in their authority and instituted for their benefit. They have therefore an unalienable, which means it cannot be separated or transferred, and indefeasible, cannot be made void, right to institute government, and to alter, reform, or totally change the same when their safety and happiness require it. And here's a maxim of law, 7K. Whose it is to institute, his it is also to abrogate. Where did alter, reform, or abolish originate? The Declaration of Independence, penned by Thomas Jefferson. This is an excerpt from that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. Remedy, right of revolution. And the word revolution means a change in the constitution of government. In the New Hampshire Constitution, Part the First, Article 10, it's entitled Right of Revolution. Let's see what this says. Government being instituted for the common benefit, protection, and security of the whole community, and not for the private interest or emolument of any one man, family, or class of men. Therefore, whenever the ends of government are perverted, and public liberty manifestly endangered, and all other means of redress are ineffectual, the people may and of right ought to reform the old or establish a new government. The doctrine of non-resistance against arbitrary power and oppression is absurd, slavish, and destructive of the good and happiness of mankind. And here's a maxim of law, 94N. Where the ordinary remedy fails, we must have recourse to what is extraordinary. So the people have the right to change our government at will when it's necessary. Dissolution of Government. The Founding Fathers relied on John Locke's two treatises of civil government from 1689 as a resource when forming the new American government. When government became so perverted that it needed to be changed, Locke's Dissolution of Government provided a remedy to raise up a new government for themselves and their posterity, and as a remedy in the event of corruption in their new American government system. Here are some excerpts regarding the dissolution of government. This is from Chapter 19, Section 220. In these and the like cases, when the government is dissolved, the people are at liberty to provide for themselves by erecting a new legislative, differing from the other, by the change of persons or form, or both, as they shall find it most for their safety and good. For the society can never, by the fault of another, lose the native and original right it has to preserve itself, which can only be done by a settled legislative and a fair and impartial execution of the laws made by it. Here's a maxim, 7G. By the same mode by which a thing is bound, by that it is also released or dissolved. Contrary to trust. These are excerpts from Section 221. There is, therefore, secondly, another way whereby governments are dissolved, and that is when the legislative or the prince, either of them, act contrary to their trust. First, the legislative acts against the trust reposed in them, when they endeavor to invade the property of the subject and to make themselves, or any part of the community, masters or arbitrary disposers of the lives, liberties, or fortunes of the people. See, the people have, by God, the right to life and liberty, and no one else has rule or authority over that. A state of war with the people, and this is taken from Section 222. Whenever the legislators endeavor to take away and destroy the property of the people, or to reduce them to slavery under arbitrary power, they put themselves into a state of war with the people, who are thereupon absolved from any further obedience and are left to the common refuge which God hath provided for all men against force and violence. Whensoever, therefore, the legislative shall transgress this fundamental rule of society, and either by ambition, fear, folly, or corruption, endeavor to grasp themselves, or put into the hands of any other, an absolute power over the lives, liberties, and estates of the people. By this breach of trust, they forfeit the power the people had put into their hands for quite contrary ends, and it devolves to the people, who have a right to resume their original liberty and by the establishment of a new legislative, such as they shall think fit, provide for their own safety and security, which is the end for which they are in society. The people are the judge. This is taken from section 240. Who shall be judge, whether the prince or legislative act contrary to their trust? The people shall be judge. For who shall be judge what his trustee or deputy acts well, and according to the trust reposed in him, but he who deputes him, and must by having deputed him have still a power to discard him, when he fails in his trust. If this be reasonable in particular cases of private men, why should it be otherwise in that of the greatest moment, where the welfare of millions is concerned, and also where the evil, if not prevented, is greater, and the redress very difficult, dear, and dangerous? In closing, the Founding Fathers reserved all power and rights of freedom and liberty to the people. The people are responsible for the oversight and control of the government. The Founding Fathers reserved the right to alter, reform, or abolish government when necessary for the public good. Thank you for watching this video. Please share with others, click like, and leave a comment to help get this out to more people. Please subscribe. Thank you.